Get ready for the dictation in 3, 2, 1, start. Learned Standing Counsel appearing for the petitioner employer contends that since engagement of respondent workman was on contract basis, he could not have been granted relief of reinstatement along with continuity of service with 75% back wages stop. It is also urged that claim before labor court is barred by res judicata as claimed stood rejected by the Public Services Tribunal stop. It is also argued that finding of continuous working of 240 days in a calendar year is based upon no material and that in the facts and circumstances of the case no adverse inference could be drawn against the petitioner employer inasmuch as the records demanded were not in existence at all. Stop. It is also stated that even if a finding of violation of Section 6 of the Act was returned, at best monetary compensation could have been awarded, but relief of reinstatement along with 75% back wages is preserved. Stop. From the materials placed before this court, it appears that although a claim of regularization had been filed before the Public Services Tribunal, which was rejected on the ground that respondent workman is a daily wage employee and not a regular government servant. Stop. It is not in dispute that issue of validity of termination was not the subject matter before the Public Services Tribunal and therefore the argument advanced by Learned Standing Counsel that claim before the tribunal was barred by res judicata cannot succeed. Stop para. So far as the engagement of respondent workman is concerned, it is alleged that he was appointed on contract basis. Stop. Such a plea, however, was not taken in the written statement and was taken for the first time in rejoinder statement. Stop. It is further recorded by the labor court that no agreement or contract has been produced in order to demonstrate that engagement of respondent workmen was on contract basis. Stop. The alleged letters filed as Annexure 7 to the writ petition recording that monthly wages of persons engaged on contractual basis are being released were not filed or proved before the labor court and therefore such documents need not be entertained and scrutinized by this court at the first instance. Stop para. So far as the working of respondent workman from February 1994 onwards is concerned, a finding in favor of respondent workmen has been returned essentially by drawing adverse inference against the petitioner employer. Stop. A specific direction was issued to the employer to produce attendance register and wages register for the period in question, which admittedly was not produced. Stop. The defense taken that in respect of contract employee such registers are not maintained has been rejected in view of the finding that petitioner employer had failed to establish that respondent workman was engaged on contract basis. Stop. The labor court also relied upon the certificate issued by Deputy Sports Officer dated 10/8/1999, which was duly exhibited and proved. Stop. Petitioner employer has not been able to dispute such certificate. Stop. The labor court has further relied upon a communication of regional sports officer dated 12/1997 for payment in respect of various employees, including respondent workman. Stop para. Learned Standing Council has relied upon a judgment of the Apex Court in R. M. Mittal versus Assistant Executive Engineer 2006 8 SCC 213 in order to contend that it is for the workman to establish his continuous working stop. This judgment would not be of much assistance to the petitioner employer inasmuch as, in the facts of the present case, the workman had discharged his onus by adducing his oral statement and documentary evidence coupled with adverse inference which led to a finding of 240 days working being returned by the labor court. Stop. Two important documents, that is the certificate of working as well as release of remittance to workmen, had been brought on record and proved. Stop. Petitioner's case of contractual employment has been disbelieved for cogent reasons. Stop. The non-production of attendance register and wages register was also material. Stop. Thank you.